why make fair housing compliance a priority from the landlord's standpoint? And one, it's the law. And we heard Mr. Block tell us all about the genesis of the law with the Civil Rights Act of 1968. It's Title 8 of the Civil Rights Act. And I believe it was signed into law by President Johnson soon after Martin Luther King was assassinated. So it does have a genesis back to that same body of law that's so important to our country. Noncompliance is the denial of civil rights. So it's not just the denial of an apartment for someone or denying some attribute of housing, but it's actually the denial of a civil right. And so it is an elevated and very important part of the jurisprudence and fabric of this country. And then, as Wendy Olson emphasized to you, noncompliance is extremely expensive. Whether it's defending a HUD complaint, participating in an administrative law judge proceeding, whether it's going to court, it costs money. As much as I love landlords in doing this, I don't do it for free. Most attorneys don't. And the litigation and the law and legal representation is expensive. Apart from that, the consequences, in that you've heard about penalties, you've heard about compensatory damages for people who are aggrieved under the Act. You've heard that there's potential liability under some circumstances for punitive damages, and some circumstances paying attorney's fees and costs of the other side if you were not to prevail in the proceeding. So there are a lot of reasons why to make this a priority, and the expenses is certainly one well known to a lot of landlords. So, you know, where do you integrate this fair housing awareness into the work of a landlord? Well, it's usually good to start early and start at the very beginning with the hiring of staff and making fair housing part of that hiring process. Interview prospective employees, find out about their knowledge and experience. Determine what training needs to be done for new hires, including volunteers and temporary staff, and include fair housing policy statement in the employee hiring packet. The agreement by employees not to commit acts of harassment is often a statement in an employee handbook that most people, when employees, have to sign. Well, when you're hired to work for a landlord in the housing industry, there can also be a statement included that the new hire is aware of the Fair Housing Act, has received or will receive training on it, and agrees to comply with both the landlord's policies and procedures for fair housing compliance and the Fair Housing Act. The importance of training new hires, including volunteers and temporary staff, I can tell you that some nonprofit shelters have had problems, have run afoul of the Fair Housing Act, or at least been accused of running afoul of the Fair Housing Act, when they had volunteers who weren't trained in the Fair Housing Act sitting there answering the telephones for the shelter. And they received test calls. The person calling said, I'm a person with a disability, I need to come and stay at your shelter, and I have a dog that is my comfort animal or service animal. And the person answering the phone, and it's amazing how much this occurred repeatedly, answering the phone would say, well, I don't think we allow animals in the shelter. Easy mistake to avoid, and that is to have training even for that volunteer, even for temporary staff. And it's become extremely important to have training for maintenance staff, because maintenance staff often has the most direct daily contact with tenants. And we're going to get into this in a little more detail later when we talk about disabilities and requests for accommodations. But it's very often that the tenant feels that that maintenance guy is, or woman, are the person that is most approachable, that they can go to and they can talk to. And we're going to cover the fact that a request for accommodation can be made verbally. It doesn't have to be made in writing. Even if you have forms, it can be made verbally. So how many people are in maintenance for properties? Okay, yeah, a good number. So good, glad you're here. So then you've got the new hire, and you've got your existing staff, and you've got everybody from maintenance right up to the home office. You've got people who answer the phones. Everybody should be trained with regard to the Fair Housing Act and the requirements. Training early and often, in-house training. I mean, you can have people cover small sections. I do training for landlords and their staff on a number of topics, including fair housing compliance, how to set up and process requests for accommodations, just to name a couple of topics. But people in-house can do it. Okay, people in-house can certainly do it. Outside training, well, it's what you're here for today. But there is training. There's, I think it's HUD has a free webinar online that you can sign up for through their website, and at your desk, sit there and obtain basic fair housing training. So, and it's free. So, free's good. It's a lot of opportunities to get that training, and you know, fair housing it's constantly evolving. Courts are interpreting law. HUD promulgates rules, and so and things change. So it's often good to have that update annually, and not just on a federal level. While it doesn't include the Fair Housing Act, most people realize, for example, the city of Boise passed an ordinance, I think it's well over a year ago, that says it's a crime to discriminate against people based upon sexual preference or transgender. So that would be a bit of information that if you're paying attention annually, someone would pick that up and make people aware of it. Marketing. Here again, I would bet everybody here that has an office at an apartment complex has a fair housing poster posted in that office. In addition to that, you should have a fair housing policy. And you should look at your advertising. This is a big area, a fertile area where there's a lot of enforcement action when it comes down to the advertising. And advertising it says advertise the attributes and amenities of the property. Pool, parking, playground, size of units, location within the city. Those are all good points that can be made and brought up, and those are fine. But you don't want to advertise what are you looking for in a resident, because that makes anybody not described by you unwelcome. And then the other main area that comes up is steering when showing the property. A lot of the properties have multiple buildings. Some buildings might be closer to the playground. Some are closer to a busy street. So it often happens the well-meaning marketing person for the complex, or maybe it's the manager if they don't have someone in the marketing for the property, shows a couple with children some apartments and shows them the apartments that are, doesn't show them the vacant apartments up by the busy street, shows them the apartments just at the very back by the playground. Well, that manager is making assumptions that could easily lead to a fair housing complaint. Well-intended, looking after what she thinks or he thinks this family would want. And that's what you shouldn't do when marketing. Treat everybody the same, show all the available units, let them make the decision if they want to be near the playground or away from a busy street. So yeah, don't make assumptions about what the applicant may want or not want. So we've heard a lot about screening today, and you should always have a written rental policy, and that should contain the screening criteria that you'll use in the application process. The rental criteria should be posted at the property. You should give a copy of that and an application to every prospective resident. This is another area that is often fertile for enforcement action, and it's sometimes subject to testing. I haven't heard of any testing on this subject recently, but maybe it's just I haven't heard it. But very often there can be testing where someone comes into the apartment office and is asking questions, mentions their family, maybe mentions their disability, and the manager again makes assumptions about what they would want or not want, whether they're really interested or maybe they're not really interested. And so doesn't hand them a rental criteria and an application, or at least make an offer of it. But yet somebody else comes in, the manager makes judgment in their mind that, oh, well, they're a serious applicant, and so gives them the documentation. The bottom line is everybody who comes into the office looking for an apartment, regardless of the judgment of the manager, should be offered an application and the rental criteria. And then the next one I think most people know is that you don't ask about physical or mental disabilities or drug or alcohol use or lawsuits. Those are intrusions into disabilities. The more proper questions are prior evictions, money judgments, bankruptcy, and rental history. We've had some discussion today about criminal history. I guess I'll go ahead and say what I want to say about that particular issue. I'm unaware of any rule or case law that says it is inappropriate to have criminal history as part of your screening criteria. You can have it as part of your screening criteria. What I believe we heard from Wendy Olson is that if you are applying it blanketly so that you're just saying felony, gone, without considering anything else, or misdemeanor, gone, application denied, that from an enforcement standpoint, the government may view that as discriminatory because it has a disparate impact upon some classes of people. Minorities, for example, I think was the main one that she talked about. Some people say minority as well as on women. So you can have it as part of your screening criteria. And here again, I don't know of any hard and fast rule that says you can't apply it as mechanically as felony out, misdemeanor out. But you've heard from somebody in the know who has told you that is not going to be looked on with favor. That there is an argument advanced by people knowledgeable with enforcement powers for fair housing who are saying that is not the way that you should apply that criteria. That you have to bore down deeper and ask the question and focus upon whether that criminal offense affects this person's quality as a tenant at the property. You can't be that blanket. She made references to the blanket use of it. And so I think that's really the takeaway there. I would also say, given the statistics that were provided, that there should be an economic incentive to also look beyond just whether there's a felony or whether there's a misdemeanor. In that there are people who come out of the criminal justice system better than they went in. And when you get into a period of time like we are now with very high occupancy rates, you may be missing some very good tenants out there. So I think you need to, you can use it as your criteria, but I think probably what you have to take away from this is you need to look at what's the nature of the crime and the age. I think perhaps age is probably one of the biggest factors to consider. But anyway, so you use an outside agency, third-party screening service for all rental applications. Keep good records of all inquiries and applications. And why do that? Well, one reason to do that is because if you are ever called to task, you want to be able to show that you treated everybody the same. And the way you do that is good record keeping. I mean, that is the key. As a lawyer who defends these cases and these claims, it is far easier if there has been good record keeping from the very beginning. Formalize and document an appeals process. That's often important because if someone wants to appeal, there may be information there that you didn't originally have. That's usually what it's going to be, is that there's a new bit of information for you to consider. Lastly, developing a waiting list policy. This is another area that often comes up, or questions often come up. It's a good idea to keep your waiting list. I know for a long time people didn't do that. It was on a piece of paper. It was constantly changing because there were people saying, "Oh, I'm not interested any longer," and falling off the list, and it was quite a headache. But it is good to have a waiting list policy and to set a period of time and to keep waiting lists. Yes. Well, okay, so the question is whether it's a good practice for landlords just to check the Idaho repository for criminal history information versus employing a third-party screening service. The Idaho repository doesn't always tell the whole picture. That is a snapshot of just, here again, Idaho-related information. Someone may have come from out of state. The thing I would say about the repository is often it's confusing and difficult to read at times and will have information regarding arrests as opposed to convictions. And arrests are one of those things that you've got to really have to stay away from because innocent people get arrested and the cases get dismissed. And so the fact that someone has been arrested isn't reliable information if there's been a dismissal. It's an arrest followed by a conviction that would be material. So I don't think from a landlord standpoint it's good to rely upon just the repository. I guess if you're a tenant searching for housing, A lot depends upon what the repository shows. I mean, if the repository shows a conviction of a crime that in the last 3 to 5 years that would tend to weigh upon your qualifications as a tenant for that property, they don't need to do any more than that. I mean, they've found the information. But one of the things that the question touches on, though, is by using a third-party screening service, they process every application the same. They run it through the same test. They gather the same information. They apply the same criteria or information gathering parameters and produce a report. Whereas when landlords go out and start digging for information, the question is, did we dig harder on this person because we really don't want them living here, or not, or do we treat everybody the same? So I think that's one of the reasons why it's good to use a third-party screening service to gather information. Okay, so then apartment rules. This is another area that is fertile for enforcement actions, in part because so many properties are using old rules. They've been handed down from one management company to the next. Or the person who owns the complex started owning complexes, in the 60s or 70s or whatever, and they've just used this same old tired set of rules and handed it down, or maybe even shared it with a neighbor. But anyway, it produces bad results. And that you need to review those rules and make sure that that they are applicable to all residents, that they really don't run afoul of a protected class. Some of the main areas here are what it says about pets and animals. You can certainly limit pets, but I think a rule that talks in terms of animals is overly broad, because obviously an assistive animal or a comfort animal is an animal, but you shouldn't have a prohibition in your lease so broad that it talks in terms of animals. So other areas here that are of concern usually have to do with familial status discrimination. I'll occasionally be handed a set of rules to read and review for a client, and the rules will talk about children shall not leave toys, bicycles, scooters on the walkway. Well, it's not just children leaving them on the walkway, it's every occupant should not leave those, right? So when your rule is written in terms of children, it's not very receptive or invitive of families. And so this tends to be fertile ground for a familial status type of claim that you then have to defend. So review of rules is very important, and look at those with a critical eye. The way to overcome that is, of course, just write in terms of occupants or residents. Residents must do this. Residents must do that. And you tend to avoid at least the familial status discrimination type of claim. Provide the rules to all tenants. Post a set of rules in the office so that they're well known. Let's see here. Records. Record keeping is also very important I'm going to jump above that. Rule violations and investigation. One of the big areas or complaints that I think has come about recently has been that the management staff doesn't investigate a claim or by one tenant against the other of a violation by speaking to both sides. Somebody comes in and complains, and the next thing you know, here comes a lease violation or a notice to quit, to the tenant that's the object of the complaint. And I think it's best, one, you don't want to ever issue a notice of lease violation or a notice to quit that later you find out, well, God, I wish I had known the true facts because maybe I wouldn't have done that. Or maybe I would have just given a notice of lease violation instead of a notice to actually quit and move out. So it's good to talk to both sides. Doesn't mean you got to believe both sides. Doesn't mean that if one tells you one tells you another, that you've got to throw up your hands and say it's a tie. You can use your judgment, but it's good to at least have talked to both sides and get both sides of the story. And then lastly, record keeping. And this is important because if you're going to issue somebody a notice of lease violation and warn them, or you're going to tell them they have to quit the premises and move out, you need support for it. And you're dealing with so many tenants, so many properties, so many circumstances. 30 days down the road, you might not have a clear recollection of what went on. So it's very important to have good record keeping. Rule enforcement, again, you've got to enforce them equally as to all tenants. If you have serious violations of the lease that endanger others, drugs, destruction of the property, it only takes one time, and that can certainly be actionable under your lease to require the tenant to move out and enforce the terms of the lease. But when it's minor violations, usually what I tell people, you should use at least a 3-strike process. And you should have a document that's not a legally required document, but I like to see clients use it, that's just titled Notice of Lease Violation. It's a warning, and it has certain blanks in it for you to send so that you're sure that the tenant is getting the information, what paragraph of the lease they're violating, when it occurred, and what they did wrong. And invite them to come talk to you about it. If it's all a misunderstanding, you get a chance to clear it up. If it's a violation and this person needs to be reminded, this is the first strike. If there's a second strike and a third strike, your tenancy is in jeopardy. So it's fair warning, really, and avoids misunderstanding. Yes? Yeah. I just found it strange that they agreed that she didn't violate the lease, but we had to actually request them to rescind the lease violation. Yeah. So I'll try and repeat the question because usually I'll forget to do that, and this time Andy gave me enough time. But anyway, so if you've issued a lease violation warning to a tenant, subsequently you find out that the grounds for that are incorrect and you would not have otherwise issued a lease violation, should you rescind it on your own accord or make Andy Thomas and Legal Aid come tell you to rescind it? I bet everybody would get that answer correct. Just rescind it. Now, you don't want to have this policy of issuing lease violations and rescinding them to where the fact that you issued a lease violation is meaningless. something's wrong if that's where you are. You're not talking to both sides. You're not getting the facts before you issue the lease violation. But in a case where you issue it, the tenant comes and talks to you, you have more or better information, and otherwise there wouldn't be a lease violation there. There's no dishonor in rescinding it. I mean, you've actually done what the lease violation system should do. You've gotten the word out there. They've come to see you. They've given you better information. You now have better information, and you act upon it. Yes? Well, okay. Well, what I like to see in that circumstance is you have pet rules if you're a pet-friendly property, and then you have rules that apply to service animals. And they're different rules that quite a number of reasons that they're different. But generally speaking, and there's an ADA overlap to some degree in common areas with the animal. But you can enforce the animal being on a leash. If it's a comfort animal and it's a service animal, unless having the service animal on the leash interferes with the service animal's ability to provide its service. If it does, then you can't require that it be tethered or harnessed or leashed. But barring that exception, you can require all of the animals to be on a leash in the common areas, certainly. But the best thing to do is to have a set of rules for the service and comfort animals and a set for the pets. Okay? All right, so we're on rule enforcement. I think we covered that. Okay. Everybody's favorite topic, the reasonable accommodation. You should have a written accommodation request procedure. This is the one that tells your employees how they're going to handle it or how you as the employee are going to handle requests for accommodation. And also you can have it so that it tells your tenants how you're going to process requests for accommodation. So this is your procedure. What you have to keep in mind is that a request for accommodation can be made verbally or it can be made in writing. A lot of people have, or companies have, forms for a request for accommodation and verification. It's fine to have those forms, but if a tenant comes in and says, I need to request an accommodation for a service animal or a comfort animal, you can't say, well, you must first fill out these forms for us to do anything about it. You can't impose that requirement. You can fill out the form to advance the request made by the tenant, but the tenant can, yes? Yeah, do I need to okay, so the question is going back actually. Someone snuck in under the wire on the last slide, and they wanted to know how much time you should allow the tenant to come in and address if they get a notice of lease violation. There's no law on giving a notice of lease violation. It's different from a notice to quit, where you're saying you must come into compliance and move out, or you must move out. Notice of lease violation is part of, I guess from a landlord standpoint, it's the preliminary case building if there is a case, but you're kind of giving a warning to the tenant that, hey, we may have some issues here. Let's share some information and find out what's going on. So there's no magic to it being 3 days or 10 days or 1 day. But 3 days is probably reasonable. I mean, we all know that the law provides 3 days to pay or quit. So if you've got that issue and 3 days is reasonable, 3 days should be for this as well. So there's no magic time to it. Okay, so reasonable accommodations. But like I said, you should have forms, and you can offer the forms to the tenant. You just can't require it. And the beauty of a form is that it avoids a lot of misunderstanding. What you said, what they said, what they're asking for, what the time frames are, and it helps with the system. So, you have one for the tenant to fill out saying, here is the request that I am making. And then there's a form that is a verification form. And most of you who have certainly been to fair housing on reasonable accommodations, and I think Zoanne's going to talk about it this afternoon, she's probably going to cover when you can ask for verification of information and when you can't. Am I stealing your thunder? You're doing fine. Okay. So, and, you've got to temper use of the verification form. And just the quick example is the person comes into the office. Obviously, they're sight impaired. They have a dog leading and assisting them. You can't ask for the verification form for them to fill it out because it's obvious that they need a service, and their request is for a service animal. They need the service animal, and they obviously have a disability. If it is not a disability that's obvious, nor what they would need for an accommodation and its relation to a disability are obvious, then you can ask that they take the verification form and go get the information from their medical provider and bring it to you. Kind of the state of the art anymore is to get away from the landlord getting an authorization from the tenant for the landlord to go get the medical information. We've all heard of HIPAA and HIPAA rules, right? Medical privacy. Well, it just works. It works better for the landlord, frankly, if the landlord doesn't have that responsibility. Your form can say that the tenant authorizes you to take possession and review whatever they give you. But as far as the burden is on the tenant to go get the information that would be required for verification. I think it's a good idea for companies, as long as you have enough staff and are large enough. You should have a senior individual in the company well-versed in fair housing and reasonable accommodations to oversee the request process. There are some cases out there that say if a request for accommodation isn't processed within a certain amount of time, it's tantamount to a denial and discrimination against a person with disability. So having someone in the oversight position gives you another set of eyes. It's tough for the manager there at the front desk at a property to be the person making the decisions on requests for accommodation. Certainly if there's going to be a denial, or you think there may be a denial, having somebody else involved is important. And then lastly, is that even if you're going to deny it, that's not the end of it, and that's not really the mindset. The mindset is, well, we can't grant or don't feel like we should grant what the tenant is asking, but is there something else that we can offer that we can do that addresses the tenant's concern? And that's called the interactive process. And that some cases it might just be a denial. But if there is something else that you could offer, it's kind of like a compromise, I guess, that would help meet their needs but would not be a burden on the property, either financially or administratively or whatever, then you should certainly propose it. In fact, the law requires it. And then the last thing I would just add to that is throughout this whole process, and part of the training here is to make sure that there's no retaliation to someone asserting any of their rights under the Fair Housing Act. Probably is, again, one of those areas that good training, I think, prevents it. There's no reason to take it personally, and having a good procedure and policy would help. So, miscellaneous points. Monitor and review your policies, procedures, and practices. Good record keeping, right from the application process through a manager maintaining logs and disciplinary matters, requests for accommodation. And then lastly, do not be afraid to ask for help. That's what HUD is here for, Intermountain Fair Housing Council. Attorneys, legal representation. It's a service I provide to my clients. I would much rather get a call saying, how can we address this issue, or am I doing this correctly, than to get the call that, God, we just got served with a HUD complaint. And I think most of them would appreciate that too. How are we doing for time here? 15 minutes? Well, I think I might have missed a slide. No? Well, we got them all. Questions? I see a question way in the back. Well, I don't know. I know that there are certainly some that do. Certainly housing providers are an industry, and so if you're doing work for that industry, like myself, I tend not to represent tenants, although occasionally it's happened, but usually not in the multifamily housing arena. It's been something different from that. But if you are a tenant and you think you have a case, there's the Idaho State Bar, which, well, yeah, all I can tell you, the Idaho State Bar has an attorney referral service. And there's Idaho Legal Aid well, I don't know what to tell you then. You just about exhausted all the resources, I guess. I'll take some more questions, but I also want to mention another good source of information, and that is the IdahoFairForum.org. Everybody's probably picked one of these up today. This is Eric Kingston at Idaho Housing Finance Association maintains this site. It's a great wealth of information, can put you in touch with other sources. And so if you haven't gone to that site and you have a moment, you certainly should. It's a great source of information. Yes?
I do have a question. Because, we get a lot of reasonable accommodations for companion or whatever animal, which is fine. But is it okay when they hand me a letter, and the letter is dated 4 or 5 years ago, which happens fairly frequently, because they'll get a letter from about 4 years ago, and they'll copy it, and that's what they'll use. Is it reasonable to say, hey, can you go back to the care provider, just give me something that's more recent? It's repeated. Can we ask for that or not?
Okay, so the question is, the tenant comes in, they're looking for an accommodation for a service or comfort animal. Let's say comfort animal, okay. A comfort animal, and they have a document that's maybe 5 or more years old from someone verifying the disability and the need for the animal. Can you ask that be updated? Well, I haven't heard that question before, but that's a darn good one. I guess I would, I don't know that I would want to picket that or not. I mean, that seems like a trouble area, and then the question becomes, what's the reason for wanting the additional information? And the reason I picked on comfort animal is because it's not readily apparent that they have a disability or not. So I think I would just, if it's 10 or 20 years old, maybe stronger too, maybe, but certainly in the 3, 4, 5, anything less than 10 years, I think I would be inclined to go with it and not have them re-update it or revalidate it.
We've received some, and I have to tell you, they don't always they look sketchy, okay? They come across that way, and they're copies of copies of copies. We call the numbers, no such person exists. Sometimes we just want to make sure they're, this letter, it is who it is.
Okay, well, I guess that's your...
I'm going to these are all the frequently asked questions I'm going to address in the next section.
Okay.
And so I want to make sure that, I think you've given similar answers that I would give, but we can talk about maybe processes to deal with that, which I agree. I think David's answered them quite well,
Yeah.
but we can talk about it specifically. You're answering you're like advanced service animal questions. It's awesome.
Yeah, they are. I mean, you're asking questions for which there's no rule or something that anybody can look up. It's a judgment call. And so, you have a question? Okay. Okay. Well, there are occupancy standards, and it's part of the tenant criteria for properties. And it's kind of interesting. There's been a lot said about this, too. A gentleman from HUD by the last name of Keating a long time ago issued a memo that was interpreted, at least heavily within the industry, of setting a presumptive validity of 2 persons per bedroom. Okay? The memo also went on, though, to say that in certain circumstances, that presumption of 2 per bedroom may not hold up, and that you would have to look at such things as the age of children, the square footage of the unit, whether it had an office/study or a loft that would be treated as another bedroom. But given the scenario, do you know the ages of the children? All under the age of 5? 3, probably, and it's a 1-bedroom? Okay. Here again, no hard and fast rule on that without more details about the apartment, but probably they could enforce that occupancy standard.
What about the children that are over 10 years old?
Well, then certainly. I mean, it's the infant, the addition of the infant to the family where there's a question. But once children are beyond the infant age, usually they're picked up and counted the same as any other occupant. And so, yeah, that the landlord could do what she's talking about, and with a 10-year-old or 10-year-olds, they would certainly be counted as an occupant. So, I mean, you hear a lot of things. You hear 2 per bedroom. You hear 2 per bedroom plus 1 as a safe harbor or a place where the landlord could draw their occupancy standard. But the bottom line is that, and I believe this still rings true, the starting point is the 2 per bedroom. And then you look at the other factors and decide, is that reasonable in light of, do people exceed the 2 per bedroom because there's an infant under the age of 2 that's living there? What's the square footage? I mean, typically if it was a 1-bedroom with mom and dad and an infant child, that's 3 people in a 1-bedroom, but it's not reasonable to evict that size. 1 adult with 3 children, presumptively at least a couple of those over the age of 2, the landlord could probably do it, could probably make them relocate.
David, can I add something to that?
Sure.
So we have worked with cases like that, and David's very compassionate, and one of the alternatives that we came up with is that they were able to transfer the family to a larger unit. So always think outside the box. While eviction may be one option, if you work with those creative, compassionate people like David, you can always come up with, I think, better solutions. So that's one thing I would say thank you for that. So look at those other options as well.
Okay, other questions? Again, yes. Well, yeah, so the question is there any advice for perhaps tenants seeking housing who are in fear that when they pay their application fee that they'll end up actually being denied, and they've lost their fee that was hard to come by, and it may be upon a factor that you'd think the landlord would know in advance. I have had this come up. I'm actually trying to recall exactly how we addressed that particular circumstance. Actually, it had happened in a case or circumstance, and it was so rare that the landlord actually gave the fee back. They just said, we understand your circumstance, and this was tough to do, and this doesn't come up very often, and we understand, and we'll just give you your application fee back. It certainly wasn't a policy of theirs, but they appreciated the circumstances and did it that way. For the tenant, if your credit score is such that you're not going to meet the criteria of, and this is part about having the criteria posted and available, if you're not going to meet that criteria, then I think you need to be talking to them up front. Landlord's probably hemmed in and has to at least invite and can't go too far of discussion, whether you should apply or not, or running the risk of discouraging someone from applying, so they can't do much up front. But I think you've got to appreciate the market. And if the conventional multifamily landlord's criteria isn't something that the tenant can adjust to, then they may be looking at they might be looking at the single family resident, where criteria tend to be more relaxed, or landlords feel like they have more flexibility. Yeah. Anybody else? Any other questions? Okay, well, I appreciate this opportunity to speak with everybody. And
we're going to take a 15-minute break. There is material